Hello, my name is Damayanti Mbawalita, and today I will present you three legal articles that I have read. And for the Article 1, the judge of the Mataram High Court acquitted the defendant Arianto Pramuttu, who was charged by the public prosecutor with committing the crime of corruption under the primary charge of Article 2, Paragraph 1, and the subsidiary charge of Article 3 of Law Number 31 of 1999 on the eviction of the crime of corruption as amended by Law Number 20 of 2001 on the amendment to Law Number 31 of 1999 on the eradication of the crime of corruption. This research then focuses on examining the judge's decision to acquit the defendant of all charges, where in the decision of the panel of judges, there are several considerations that are interesting to study in more depth so that they can be used as guidelines for measuring the criteria that must be met when a judge's decision is handed down. Apart from being a legal certainty, it is also oriented towards benefits that have an impact on justice when viewed from the perspective or the theory of legal objective. As for the conclusion for the first article, based on the results of the research, it can be concluded that the judge's consideration in imposing a verdict of release from all charges due to the existence of reasons for criminal erasure in the form of justification has fulfilled the intent and purpose of Supreme Court jurisprudence number 40K/KR/1996. However, when viewed from the theories of reasons for criminal expungement of defendant Arianto Pramuttu does not fulfill one of these conditions, but the defendant has fulfilled the elements of Article 2 of Law Number 31 of 1999 concerning eviction of corruption so that the defendant's actions have been proven to have committed a criminal offense for which criminal responsibility can be sought. And for the second article, it is about fulfillment of restitution rights, efforts to restore victims of crime. This study discusses the mechanism, regulation, and implementation in the protection of witnesses and victims, especially the problem of crime victims. The forms of protection for victims of crime have been regulated by Law Number 13 of 2006, as amended by Law Number 31 of 2014, concerning protection of witnesses and victims, as an example of a form of protection for victims of crime through efforts to fulfill restitution imposed on perpetrators of crime. The method used in this research is juridical normative using secondary data or library research with the stated approach through evaluation techniques and argumentation techniques. In this study, it was also found that in Law Number 51 of 2014, there was an expansion of the form of protection for victims as a result of crime, namely through the right of restitution. Arguments that strengthen that there is a need for restitution are also found in the minutes and academic texts in the form of the legislation. As for the conclusion for the second article about fulfillment of restitution right, efforts to restore victims of crime, it can be concluded that restitution is the right of every non-criminal victim for losses arising for a criminal offense. Restitution can be in the form of compensation for loss of wealth or income, compensation for losses incurred due to suffering directly related as a result of a criminal offense, and reimbursement of medical and/or psychological treatment costs. The fulfillment of restitution is imposed on the perpetrator as the party that caused the criminal offense and loss to the victim. Through the restitution mechanism, it is hoped that victims can recover from the suffering of a criminal offense that they have experienced. And for the last article, or the third article, it is about handling of defamation crime in relation to the criminal code. This study aims to provide an explanation that regulates defamation on social media and how the criminal justice system in Indonesia can prosecute insult committed through social media. This study uses a literature study approach and normative law with a statutory approach. The results of this study found that the law on defamation in Indonesia is stated in the criminal code. We call it KUHP, and the Electronic Information and Transaction Law, and we call it UU ITE. This includes important points. First, defamation in the criminal code. Defamation is defined as a false accusation against someone that can damage their good name in society. Second, the defamation based on the ITE law. The ITE law also criminalizes defamation committed through electronic means such as the internet. The key elements are subjective intent to defame, lack of legal justification, and the act of spreading or disseminating defamatory information. Third, other related violation. The documents also discuss related violations such as false accusation in the article 317 of the Criminal Code and penal insults in the article of 315 of the Criminal Code. That's all from me. Thank you for watching.